because it involves the use of mental capacity legislation, whereby a psychologist says somebody hasn't got capacity to instruct a solicitor, and that case then goes off to the official solicitor, who then comes in and concedes the case against the parent, which is what happened in this case. We issued proceedings with that got permission in the Court of Appeal, oddly enough. Went to the House of Lords, who said go away, but we've got it into the European Court. And the interesting thing, you see, one thing we're strategically trying to do is get as many cases into the European Court as possible, because the European Court has a facility under Article 39 to initiate interim proceedings, in other words, to stop an adoption. But at the moment they don't do that, and we'll only be able to get the European Court to stop adoptions going ahead and stop the juggernaut in its tracks if we can get enough cases going through to the European Court. But the challenge is actually to kick the things off right at the start. So in other words, when the initial proceedings go through, be it an emergency protection order or an interim care order, that needs to be appealed either to the county court first and then subsequently to the Court of Appeal, which will turn it down. Let's not beat around the bush. But then it needs to be taken to the European Court. And that has to be the key strategy, because we need to get a widespread recognition that, in fact, what we're doing is going around recycling babies. We're not actually producing care proceedings. And the statistics for that are quite interesting. There's a report that's produced every year based on information known as SSDA 903, which looks at all the transactions, all the things that go on with children. And you can look at what happened in 1995 to those children taken in care then, by the age of the child taken into care, and what happened in 2004, 5 and 6, and I have those figures. And it's quite easy to demonstrate from that what's happened as a result of the adoption targets, which themselves were scrapped, was that we've increased the number of newborn babies taken into care and got them adopted. And an interesting statistical comparison is in England, round about 2/3 of the babies taken into care get adopted. In Scotland, around about 2/3 of the babies taken into care go around to their parents. And I asked Gordon Brown about why this was, when we're supposed to treat the birth family with some importance, and he said, because it's different in Scotland. Which was a very funny answer. Well, I know, but the Scottish system is different in part because there's the children's panel, which makes a big difference. However, so what we're trying to do is get these cases at an early stage and then take them through the courts, which all takes a certain amount of time, so we get them into the European courts. Because what we've managed to achieve, we've achieved two things, in fact, on the RP case. One is to get urgent proceedings in the European Court, where they're moving very, very quickly, and those people who are used to the European Court haven't seen things move this quickly. And secondly, the Equalities and Human Rights Commission, which is a body that was created relatively recently, has for the first time ever intervened in a case, and they've intervened in this case. And their arguments are in essence in support of our arguments, that people's rights are being wrongly removed from them in the courts. So that's an important part of the process. Now, I can go on. In fact, those people who saw me doing stuff on the Edge TV program saw that I could go on for 2 hours. But I think it is quite important. Do you want to come around here and talk on the camera? Yeah.
Oh, yeah. A lot of people know that I probably do a lot of European stuff. So
Yeah, I know you do European stuff.
The only thing is, when you take a case to the European Court, most of the cases you only get compensation. That's it. So when you just said that they're actually trying to overturn us or stop adoptions.
Well, no, they haven't actually got to that stage. What it is, if you remember in your case, in fact, we had a situation where the Court of Appeal, was it the Court of Appeal,
Yeah.
was looking at stopping your child's adoption.
Stay of action.
A stay of action. Now, the response of the judge was you should have applied for Article 39 proceedings in the European Court. Now, we've done that on the RP case, but they said we're not going to give you Article 39, but we are going to move a lot faster than we normally do. And in fact, the deadline for the government to respond on this was initially the 6th of Feb, I think. They've extended that, and I haven't seen the government's responses yet. So part of it is to get the European Court to recognise that we have a very serious problem in this country. Paul Rowan MP, who is a member of the Parliamentary Assembly for the Council of Europe, and the Parliamentary Assembly of the Council of Europe is the organisation that runs the European Court of Human Rights, is working in the Legal Affairs and Human Rights Committee to get a proper investigation into public family law within the UK, in fact, the family division in general. So that there are two, rather than the new normal glacial way in which the European Court works, and they're trying to speed that up, but the Russians are blocking it at the moment because the Council of Europe, which this is all about, isn't the European Union. It's a different body, and it has a lot more countries as members, like Norway and Russia, that are not members of the European Union. They're trying to speed up the initial consideration of European Court of Human Rights cases. But in the meantime, we still have two routes which can achieve something, one of which is the interim proceedings and a settlement that way. And the other one of which, on top of the interim proceedings, is the accelerated proceedings. And those we found work reasonably well recently, so we're doing quite well there.
Okay.
But it is important to get these things right. And I'm always very happy, although I can't turn up in court for people, I'm quite happy to look over people's arguments. But remember, you need to get your judgments and your orders, right? Sorry, do you want to...
How do people know that's happening to people involved in this, know about all this procedure, who to contact about the rights,
Well,
where do they get that information from?
Well, the point is this, is that everybody, when they contact us, should get an advisor. And the advisors, if they don't know precisely how to do these things, we can tell them how to do these things. Which is what this is all about. So this is all about the advisors who are here and making sure that people have a better understanding of how to take things through all the different steps
And
of
if they
court
go
proceedings.
by your own website, just as on this website, there are actually links
I
to
mean,
various...
that's not totally stupid here. 9 years ago, we hadn't got a clue. We
Not
didn't
that-
even know about the website, we didn't know about anything. We were totally...
Yeah, well, the website didn't exist 9 years ago.
For any community, how do people... Say it happened to me tomorrow, how do
Well,
they know what to do? Yeah.
The first thing is this, that
Just to Google.
if somebody comes to this from scratch, it's very confusing.
Yeah.
There's no question about that. And it's taken me, my degree is in nuclear physics, my degree is not in law. It's taken me a couple of years to learn how to deal with it all. But we've now got to the stage where we can take cases through every single step of the process and on a number of occasions. The problem being that the Court of Appeal basically will come up with a different answer to the European Court because they want to keep the lid on things, which is what they're trying to do. Now, the way we're doing things is by having a network of advisors. We've got about 50 people as advisors at the moment. Some who have more experience, like Chrissy has a massive experience, don't you? And Ian and Jerry have masses of experience. Some of people who have less experience. Part of this is an attempt to give people additional training. It's difficult because, in a sense, you have to take people through the process. So, you know, we have held a number of meetings. We held the first meeting was in 2006 March. Was it? Yeah, March 2006, wasn't it? No, was it? No, it wasn't. It was March 2007 was the first meeting. I'm going to have to go and vote. So, who wants to take over?
Oh, God.
Do you want to take over?
Yeah, I'll go
All
back
right.
to the beginning.
If you need any help, Emily, I'll stand here.
No, you can sit down if you want, Ian, please.
What?
You can have the chair.
I'm going to borrow your chair, John.
Yeah.
Living the camera on me. Right, with regards to the process, I tend to, being sort of in London more, help with the to and fro paperwork to the Court of Appeal and how to go about that. I know that Jerry is probably the best person to speak to with regards to how to appeal at a county court level or with regards to district judges and things like that, aren't you? Jerry has ever so kindly, which I haven't given out yet because it's just not, it is a lot of writing. There's another handout that Annabelle's got, and that's about the current legislation and being allowed into hearings at maybe magistrate level, district level. Yeah. And that, I haven't given that out yet, only because it would just be lots of people reading a lot of things. But thanks, Jerry, for doing that. Did you want to go through how you've been through
It is difficult because I can never remember how I actually got involved in this. It just happened for some unknown reason, and I've decided to carry on. I've been doing it for now for a good few years.